My name is Laura Baker, and I'm the president of the Nashville Bar Association, and I'd like to welcome you to the training for the Small Business Pro Bono Legal Clinic that we are having beginning next week. This legal clinic is a partnership between the Nashville Bar Association and the Tennessee Alliance for Legal Services, and it is geared towards helping small businesses with the financial turbulence that many are experiencing during this time of the COVID-19 pandemic. You're going to hear today about helpful information on clinic logistics, and we're also going to give you some information on questions that you are likely to encounter as you take calls from small businesses about their legal issues. Small businesses are the fabric of our local communities, and while many large corporations may be able to stem the financial woes that they are experiencing during this pandemic time, our small businesses are struggling with closures and other financial issues arising out of this pandemic. So we thank you for your time and volunteering for this clinic, and we thank the Nashville Bar Association Bankruptcy Committee who is spearheading this effort on behalf of the bar. Now you're going to hear from Tim Hughes with TALS, who is going to talk to you about clinic logistics.
All right, so hi, my name is Tim Hughes. I'm an attorney with Tennessee Alliance for Legal Services. My normal day job over there is to run our statewide pre-legal helpline, 844-HELP-FOR-TN. But today I'm here just to give you kind of a brief nuts and bolts about a new telephone-based clinic that we're getting ready to start for the benefit of small businesses. So what is this? It's just going to be a telephone clinic. It's hosted by the Nashville Bar Association and Tennessee Alliance for Legal Services. We're going to be assisting clients with issues that really fall into kind of three different categories. We're going to have a debt category where we deal with insolvency and rent abatement. We're going to have SBA loans, dealing with EIDL loans and Paycheck protection program, and then COVID-19 general employment law issues. So when is this? It's on April 29th, and it'll be from 11 o'clock to 1, with the goal that we'll probably be repeating these going forward on Wednesdays. And what we're asking for is volunteers to give 1 hour of their time during that time slot where you can help two small business owners by doing 2 30-minute telephone calls. So to volunteer, what we'd want you to do is go to the NBA's website. There you can register, and after you register, you'll get an email that confirms you're good. After that, you'll select your practice area from the 3 topics we just talked about. You can give advice and talk to folks about any of the 3 that you are comfortable with. And then we'd ask you to put a placeholder on your calendar between 11 and 1 o'clock on April 29th. So the next step will be that the folks over at TALS, myself included, will review these registration forms from small business owners, and we'll pair them with you, the volunteer attorneys. So we'll use Attorney Mike as our example. What I would do is I would send Attorney Mike an Outlook calendar invite, and I'll do this on or before April 24th to let him know that he's scheduled to call, let's say, Joe from Joe's Dry Cleaning at 11 and Mary from Mary's Appliance Repair at 11:30. So that way, several days before the clinic, Joe will know who he's talking to and at what time. But we'll also, in this calendar invite, we're going to include the client's registration form where we've asked them questions about their business, the number of employees, and what types of legal issues it is they're facing. So the attorneys will have that in advance. This is limited scope representation, which is great. So you treat it just like a Saturday walk-in legal clinic at the library. That means you don't have to do a conflict check. They're not necessary. As far as the actual call, the business owners will have selected the time. So they should be ready, have their documents with them, and be expecting your call. So I just say that to make sure that we treat it as like an appointment. I would also recommend using *67 to protect your privacy. Otherwise, these people will probably become your clients for life, as we all know when we've given out our cell phone numbers before. The callers are aware that you're going to be calling them from a blocked number. So if the caller doesn't, so they should pick up. If they don't, what I do on the legal helpline is I just leave a message identifying myself and noting that I'm going to try to call them again in just a few minutes. So since we've had this helpline, 844 Help for TN, going since 2013, I wanted to share a few things with you. I know that all our volunteer attorneys know how to talk to their clients. I thought there might be a few things that could be unique to telephone advice. So in my experience, callers need to vent. You know, they're frustrated about their legal issue or their business is struggling. I like to let clients tell their story their way first, and then try to ask questions to kind of rein in the conversation. Another thing we've discovered is some callers don't know what their legal issue is. I think that's part of what we're doing today in having good substantive legal trainings after this piece so that we can help them to issue spot. One of the things that may come along, and it does in our helpline, is that you might find yourself talking to someone who's simply doesn't have a good legal remedy. You know, and I think we all try to have empathy for our clients and just kind of tell them, you know, we're on your team, we're with them, and we understand that the situation may not be fair, or it may be bad business on the part of a landlord or something of that nature. So that's kind of my approach to that. And then lastly, I'd say, you know, be sure you let people know about any applicable deadlines or statute of limitations, and then document it to protect yourself. So after the call, what we're asking from our volunteer attorneys is to reopen that calendar invite that I sent you and just answer a couple questions from new information you gained during the call. And I want to emphasize too, please let us know how much time you spent with each caller. You know, if you ended up doing research, taking notes, calling them back, let us know all about that, and TALS will submit volunteer time for CLE hours. And since you're covered by TALS malpractice insurance while you're giving this advice, TALS will log all this information into your helpline's case management system. Okay, so that's it. So thank you very much for helping small business owners, and special thanks to Justin Campbell and Mike Abelo for proposing this clinic and making it happen. And at this time, I will pass it off to Justin Campbell.
Thanks, Tim. As Tim said, my name is Justin Campbell. I'm an attorney with the law firm Thompson Burton here in Nashville. I specialize in insolvency and bankruptcy practice, and I am providing the bankruptcy and insolvency training for this seminar. The goal of the training here from the bankruptcy perspective is to give you a brief overview of the bankruptcy practice. We'll touch on the three major chapters that we see, and also get into a few of the insolvency issue spotting that you may need as you're talking to clients. It's not intended for this to be a very robust discussion of the chapters. However, we do want to give you some information so that if it comes up in a conversation, you can at least know the baseline for each of the chapters, and to have some information on how to spot these issues. So as you can see there, the three major chapters that we deal with are Chapter 7, Chapter 13, and Chapter 11, and I'll address those in that order. Chapter 7 is what you traditionally think of when you think of bankruptcy. That's the liquidation section. That's eligible for businesses or individuals. You need to know that there is an income-based test for individuals. However, in the business context, we rarely see that because there's an exception for business debt. If you have more than 50% of your debt is a business debt, you don't have to fall under that eligibility test and can proceed in Chapter 7. There is no income or debt test for businesses. A Chapter 7 trustee, once you file a Chapter 7 case, a Chapter 7 trustee is appointed. That trustee will collect all non-exempt assets, liquidate those assets, and generate a pool of funds to be handed out to unsecured creditors. The unsecured creditors get funds on that based on the share that they have in the claims pool. So for example, if you have 20% of the debt in the claims pool, you would get approximately 20% of the funds that the trustee has to divvy out. During this process, an individual debtor would receive a discharge of any remaining debt they have, with a few exceptions. Taxes are one of those, that student loans are one of those that are not discharged, at least at this point. And there's no going forward option for businesses. So if a business files for Chapter 7, that business essentially ceases to exist shortly after they file the Chapter 7. The next chapter is Chapter 13. That's a reorganization chapter, but it's for individual reorganizations only. Businesses don't file cases under Chapter 13. This is important because, as you may see, most small businesses or some small businesses are their own separate entity. However, some small businesses may be doing business as or a sole proprietor. A lot of trade craftsmen may work on their own, a plumber or carpenter or something of that nature may just work as their own name. They would be eligible, even though they're in a small business setting, they would be eligible for a Chapter 13. So the way this works is there's a debt repayment plan. They typically last anywhere between 3 to 5 years. The plan is calculated based on your disposable income. So whatever income is available to you following your necessary expenses is put into the plan, and you pay that plan over the 3 to 5 year period. If you're a bankruptcy lawyer on this call, I've probably just simplified that into 30 seconds worth of a very robust discussion. So there are debt limits for eligibility. It's approximately 1.2 million for secured debt and just over 400,000 for unsecured debt. A Chapter 13 trustee is appointed in these cases as well. That trustee acts almost as a dispersing agent, so they collect your disposable income each month via a check from the debtor or from some payroll deduction, and then they make the distribution to the creditors. Chapter 13 is beneficial to a lot of individuals because it allows them to retain more property than they normally would in a Chapter 7. As long as the plan is confirmed by the court and you're making your monthly payments, the Chapter 13 trustee normally doesn't go pick up, collect, and sell assets in the same way that a Chapter 7 trustee would. The discharge option is still there for individuals. However, you've got to wait until you finish your plan payments, whereas you get it fairly quickly in a Chapter 7 case. You probably won't get your discharge until at least 3 to 5 years down the road on a Chapter 13 case. So that's the reorganization for individuals. Chapter 11 is the reorganization for businesses and some individuals. This is the bankruptcy chapter that you normally see in the news. This is the bankruptcy chapter that companies like Toys R Us, Sears, Pier 1 most recently, that's the chapter that they file under. And it's a reorganization chapter for businesses or individuals. If it's an individual, it is normally a high income or high asset individual that can't qualify for a Chapter 13 case. The debtor proposes a repayment plan to the bankruptcy court and to the creditors. There's no defined time limit on a plan in Chapter 11 like there is in Chapter 13. The creditors vote on the acceptance of the plan, and then there's several mechanisms that go into whether or not the court confirms that plan based on whether or not there's an acceptance of the plan by the creditors. Again, that's a little more detailed than we want to get into for the training here, but just at least gives you an idea of how the process works. There's no trustee. The case is managed by the debtor, and creditors normally have more rights in a Chapter 11 case. They normally have more leverage to push against the debtor. And because of that, Chapter 11 cases are significantly more expensive and time intensive than a case under Chapter 13 or case under Chapter 7. So in response to that expensiveness, Congress created the Small Business Reorganization Act. It's a subchapter of Chapter 11. It was passed by Congress and signed by the President last fall, 2019, and it became effective February 19, 2020, so approximately 2 months ago. This certainly wasn't passed in reaction to COVID-19, but we do think it will be an effective tool for a lot of small businesses to reorganize who have been impacted by the pandemic. It eliminates and reduces a lot of the costly features of a traditional Chapter 11 and certainly speeds up the process. There is an eligibility debt limit. When it was passed and when it became effective, that was right at $2.7 million of contingent liquidated debt. The CARES Act, which was passed in late March this year, which you'll hear more about from Charles Robert and Mallory, that increased the debt limit to $7.5 million for 1 year. So it has a 1 year sunset, meaning this will expire in March of 2020, late March 2021. We have yet to see whether Congress will extend that sunset or not. So there is a trustee appointed in these small business cases, but the trustee's role is limited, and essentially the trustee acts as a negotiation agent in helping the debtor form a plan with their creditors to pay that back. Again, those plans can be creative, a little more creative than they can Chapter 13. They are on a more 3 to 5 year plan than the traditional Chapter 11s. And the plans must be filed within 90 days of the case filing. So that's normally not the case with the traditional Chapter 11. Those can stretch out quite some time before the plans are filed. These plans have to be filed within the first 90 days, so it certainly speeds up the process. And one key important part of the Small Business Act is that business owners can generally keep their ownership interest in the business. Not to get too far into the weeds, but that's not normally a possibility under a traditional Chapter 11 case unless you're paying all of your debt. You generally don't get to keep the equity in the business, but in the SBRA cases, there is an exception that does allow the business owner to keep their interest. So we think this will be a very useful tool in response to the COVID-19 pandemic. It's not on the slides here, but I will mention that there is another fourth chapter, Chapter 12, which deals with family farmers and family fishermen or fisheries. We generally don't see a lot of those cases filed, so much so that we didn't include it on the training here, but just know that exists. If one of the small businesses that you're talking to is a farming operation, just know that there's a chapter specific for them, which does allow for some additional protections for the farmer. So now that we've covered the major types of bankruptcy and what you need to know to at least discuss those major types, let's get into a little bit of the issue spotting for some of the insolvency issues. You may hear the clients talk about these issues, and if you do, you'll at least know that these are issues that need to potentially be referred back to the folks at TALS to set that client up with a bankruptcy or insolvency attorney. The first of those issues is landlord-tenant. As much of the state and the nation is on lockdown currently, unless you're an essential business, you're probably not open, which means you're probably not paying rent. You may want to ask how delinquent they are. Are they 1 month behind, 2, 3 months behind? That changes the narrative and the recommendation that a bankruptcy lawyer gives them. They may also have force majeure language in their lease. This may or may not allow them to abate their rent. We're seeing landlords take all kinds of different positions on rent abatement. So you may want to ask them if they've had conversations with their landlord and discuss this rent abatement. So the next issue would be tax issues. The federal government has extended a lot of the tax payment deadlines and tax filing deadlines. However, if they had tax issues before the pandemic, they probably still have tax issues now. These are some things to spot, to look for: federal and state revenue taxes, payroll taxes, which are commonly referred to as 941s. These are incredibly important because they do pass down to the business owner. The liability does for the individual who's responsible for those. So those can carry down individually. If it's an individual working as a small business, they may have their own individual income tax issues. The important thing to note here is that taxes are generally non-dischargeable in a bankruptcy case. If you're in one of the repayment plans, you can stretch out the payment of those taxes, but they don't go away. So that's something to watch for. Employee wages, a lot of small businesses are probably having trouble paying their employees at this point. But this would be more than the PPP would cover, which Charles Robert's going to get into shortly. So if they're 2, 3, 4 months behind on wages, that may be an issue to discuss. Second set of insolvency issues is secured debt. Banks, to our knowledge, are generally fairly lenient right now with some of the collection issues on secured debt. However, they are entering into forbearance or modification agreements with clients. There's a big difference between the two, so you may want to talk to the client about what they've entered into. Forbearance is basically, we agree to to not let you pay for 3 months, but know that everything we've agreed to waive or we've agreed to hold off is going to be due on that first day after the forbearance. Whereas a modification is like it sounds, we'll stretch the debt out. We'll put the debt back owing at the end of the note. And it's not due the first 3 months after like a forbearance agreement. And so two very different concepts. Both probably give you relief in the first month, but in month 3 or month 4, they both look very different. You may want to ask if the accounts receivable or cash are listed as collateral to these secured creditors. Cash is kind of the lifeblood of these small businesses, and if the secured debt encompasses the cash, the bank may be able to cut off their cash, cut off their accounts receivable, which would essentially drive the business. You may also want to ask them if they're communicating with a secured creditor. It appears that the lines of communication are open right now with secured creditors. So you may suggest that they reach out to their secured creditor if they're having trouble paying their note. But they also probably want to speak to an insolvency lawyer to understand what that means. And finally, something we see quite often with small businesses is personal guarantees or encumbrance of personal assets. Generally, small businesses alone don't have the asset base to get a note without some sort of additional business owner joining in the debt. So the 3 ways you see that are the business owner is jointly liable for the business debt. He or she is on the line of credit or on the note with the business. The business owner is a guarantor of the business debt, meaning that whatever doesn't get paid by the business would then fall to the business owner. And third, you may see that the business owner has pledged personal assets as collateral on the secured debt. Oftentimes, this is the business owner's primary residence. So if they're experiencing these issues or if they have these issues tied up, especially with the guarantor and the personal assets, they really need to speak with someone in the insolvency group. So that's some issue spotting things to look for as you're talking to these folks. Again, I want to extend my thank you for agreeing to volunteer and help. Thank you for all you're doing. I hope you're staying safe and healthy. And at this point, I will hand it over to Charles Robert Bone, who's with Bone McAllister Norton, and he will discuss the Small Business Administration's PPP and EIDL loans. Thanks.
I'm asked to cover the training under all the new stuff with the Small Business Administration, particularly that came about as a part of the CARES Act. So there are 3 kind of principal things that we'll cover in very short order. The first is the Paycheck Protection Program, which is the most significant, the most widely used, and has consistently been in the news. The second is the Economic Injury Disaster Loans, EIDL, which is another borrowing opportunity, and then wrap up with just a couple of additional small business benefits. The first, as I mentioned, and has been the primary source of a lot of interest, and that we would suspect that small business owners would have questions about, is the Paycheck Protection Program. This is a $349 billion forgivable loan program available to small businesses, sole proprietors, independent contractors, and most private nonprofit organizations that have been substantially affected by COVID-19, quote unquote. Loans are available, according to the legislation, are available through June 30th, 2020. Today is April the 16th, the date of this video, and the news reports of a couple hours ago, as expected, is the full $349 billion has been allotted. The House and Senate are working and debating on an additional appropriation, so SBA has to wait on that. Hopefully by the time of this program, by the time of this clinic, that will be well behind us. Most everything you read is discussion around an additional $250 billion for this program. In order to qualify, you must have 500 employees or fewer, or meet other current SBA size standards, which is a little more of a complicated analysis, but the vast majority of small businesses are going to have the 500 employees or fewer. The loans are up to the lesser of either $10 million or 2.5 times 250% of an employer's average monthly payroll cost. So for most banks, what they're asking for is an employee roster. If the client has a payroll provider like ADP, that's a really easy report for them to run. In addition to that, banks are looking at Form 940s or 941s, which are the quarterly and annual reports that you file for federal payroll taxes. So it's really easy for a bank to verify what your average has been. The average can be one of two time periods, either just your average monthly payroll for 2019, or for the preceding 12 months from the application. So for most folks, that's been 2019, just because those are really easy quarterly forms for the bank to check, verify. But for some, if it makes more sense, you can use the last 12 months to get that average, multiply it by 2.5 times, and that is your loan amount. Now, the loan proceeds can be used for employee salaries, mortgage payments, particularly interest, rent, utilities, and any other debt obligations or interest obligations that were incurred before February the 15th. Now, the covered payroll piece of that, so how do you calculate your payroll in addition to the 940, 941, is salaries, wages, and payments of cash tips up to an annual salary of $100,000. So, for instance, if an employee makes $125,000, you can only count $100,000 of that in your annual calculation, and then for the monthly average. You also get to include anything that you've paid for group healthcare benefits, including insurance premiums, retirement contributions, and covered leave. Anything you've paid the business owner for vacation, parental, family, medical, or sick leave. Anything paid for dismissal, separation, and if there are state or local tax that are assessed on the compensation of the employees. Now, what makes this program so attractive is the loan can be forgiven so long as it's used for 8 weeks of payroll cost, mortgage, interest, rent, and utilities. And so essentially from when the loan is closed and funded, you've got 8 weeks to spend it on those costs that are incurred and paid during that period. 75% of that has to go for the payroll cost, and up to 25% of that can go for the non-payroll costs, which include interest, rent, and utilities. If there is a remaining loan balance, meaning only a portion of that was forgiven because either the entire amount was not spent over that 8-week period, because you did not maintain payroll, or because more than 25% of it was spent on the other cost, then the remaining loan balance will have a maturity of 2 years with a fixed interest rate of 1%. All payments are deferred for the first 6 months, although interest accrues during that period. The program is retroactive to February 15th, 2020, and it's really done to help incentivize to bring back workers who have been laid off during this period and bring them back onto the payroll. For most small businesses, you don't have to worry about affiliation rules, but affiliation rules means for anybody who owns or controls a majority of this business, if they have other businesses in which they also own or control, then all of your number of employees get aggregated together across all of those businesses to determine whether you have 500 employees or less. However, that is waived if you're in the hospitality or restaurant industry. So if you're a hotel, restaurant, food service provider, or otherwise, you don't even have to worry about the affiliation rule for the 500 employees. Repayment ability is not a factor in approval. Instead, all the banks have to do is determine whether the business was open on February the 15th and had employees on the payroll. The second program that's a part of this, which is not a new program, has been with the SBA for a long time period, but only gets enacted in disaster areas is the economic injury disaster loans. So this is the Small Business Association offer of low interest federal disaster loans for working capital to small businesses that have suffered substantial economic injury as a result of the coronavirus. Any economic injury disaster loan declaration issued by the SBA, which has been done, makes loans to small businesses, again, with less than 500 employees, and private nonprofit organizations to help alleviate the economic injury that's been caused by COVID-19. Important to know that the borrower must have suffered working capital losses as a result of the disaster and not some other cause. These loans are up to $2 million and can provide vital economic support to small businesses to help them overcome the temporary loss of revenue that they're experiencing. These loans may be used to pay expenses that could have been met had the disaster not occurred, fixed debts, payroll, accounts payable, and other bills. So unlike the PPP, it's not restricted on exactly what it can be used for. It's a much broader set of uses. The interest rate on these loans is 3.75% for small businesses and 2.75% for nonprofits. The SBA offers these loans with long-term repayments in order to keep the payments affordable. Some can have a maximum up to 30 years. The terms are determined on a case-by-case basis based upon each borrower's ability to repay, including your acceptable credit history. Loans will not be declined because of a lack of collateral, but they try to get collateral and borrowers to pledge what is available. And unlike the PPP, where you got to go directly through a bank, the economic injury disaster loans are available and administered directly by the SBA, which you can either do online, you can mail the package overnight, you can fax it or scan it in and email it. But it is a pretty formal application. Unlike the PPP, which is a 2-page application and check the box, this is a more formalized application, requires the personal financial statement for any general partner or owner that has 20% or more of the businesses. Get into the same issue with affiliated businesses for any general partner or 20% owner who owns more than 50% in other businesses. The applicant, the borrower, has to show all of its liabilities, has to provide tax returns, and has to show sales figures and projections just like you would with any loan. Now, interestingly enough, can a business receive both a PPP loan and an EIDL? And the answer to that is yes. So businesses can apply for both loans, but you cannot obtain both loans for the same purpose. So you couldn't go as a part of your EIDL application and say that this was going to cover May payroll, and at the same time use the PPP for May payroll. So there are certain instances in which a business would have not just payroll needs, but also other needs, working capital, accounts payable, et cetera. And so you can get 2 loans. They just have to be used for different purposes. So a couple of factors in determining, what a business should consider, whether the PPP route or the EIDL. One is eligibility. They're a little bit different for each program. 2 is the maximum loan amount. So keep in mind that the PPP loans are capped at $10 million. With the applicant's limit determined by the payroll formula, where EIDLs are capped at $2 million. Loan forgiveness, the entire PPP can be forgiven if it is spent on the correct purposes, but the EIDL, other than the first $10,000, which can be an emergency grant, the remainder part of that loan is not forgiven and must be paid back. The maturity, again, the PPP loans can go up to 2 years or do go to 2 years. EIDLs can go up to 30 years. Interest rate, the Paycheck Protection Program, interest rates are capped at 1%. And again, the EIDL between 2.75% and 3.75%. So just a couple of things to note, just as you kind of get familiar with both of those programs. And a couple of other things just to note that's in a lot of this legislation that has been filed and is moving very quickly. I think as most folks know at this point, most lawyers know, the tax return filing and payment deadlines, not just for individuals, but also for businesses, has been extended to July 15th. There's also tax credits available for businesses with less than 500 employees to cover and reimburse you up for 2 weeks of paid sick leave, either for employees who've been quarantined, who have a sick family member and they're caring for them, or have been affected by school closures, meaning that you are home with your children because school has been closed. One other feature is that payroll taxes due to the IRS through the rest of 2020 can be deferred, with 50% of those deferred payments due by December 31, 2021, and the remaining 50% by the end of 2022. However, this program is not available if you go the PPP route, where you're going to have indebtedness forgiven. So if you go the PPP route, you cannot defer your payroll taxes, but at the same time, for some reason, if PPP is not available or is not an attractive loan program, then you do have the opportunity to defer your payroll taxes. And one final thing, this increases the amount of interest expense that businesses can deduct from 30% to 50% for both 2019 and 2020. So a lot has, this is landmark legislation. The CARES Act was a $2.2 trillion program that was passed in less than a week's time. It has been functioning here for the last 2 weeks. So an amazing amount of work and federal regulation all has transpired in just really the last 3 weeks. Again, the PPP program has exceeded met its lending authority. We suspect that additional funds will be appropriated in the next couple of days, and that program will continue. And there may even be some changes in it. So here's just one example, which is under the PPP, as we mentioned earlier, all of these funds have to be spent within an 8-week period, but that's going to be hard for some of your non-essential businesses and or restaurants. So if a restaurant is closed and maybe can't open again until mid-June, they close on the loan this week, they could still be closed for the next 8 weeks. So you've got the restaurant associations and others asking Congress to consider extending that 8-week period to 12 weeks or to 6 months, or starting the 8-week period from the day in which they have the all clear and can reopen. There was a lot of flurry to get this money out and get it into the hands of business owners and hopefully into the hands of their employees. So a lot of work happened, and interpretation and guidance on the fly trying to get the money out. I think what you'll see now in the coming days and weeks is additional guidance on questions around forgiveness. All of this is available on the SBA's website. They've been updating their guidance every couple of days and providing additional information as questions come up. So a lot to take in here, but know that most of these businesses can qualify, and most of them can qualify for the PPP. I would expect the questions you get are going to be around how do you apply. You need to go to your bank, work with your banker, have your payroll records, and then I suspect that some questions are going to come up about how those loans are forgiven. And so with that, I think I'm going to turn this over to Mallory, who's going to talk about training for the employment law piece of this.
All right, thank you so much. I appreciate it. For those of you who have been sitting through this training so far, I just want to say thanks for being here. Thanks for volunteering. And by the time you get to my presentation, you probably have had a lot thrown at you, and it's a lot to digest. So I'll tell you, my goal with my presentation is not necessarily to teach you all about employment law for those of you who don't practice it, but to teach you how to issue spot and know when you need to send your caller to an employment lawyer. I believe that we're going to be having employment lawyers taking phone calls. So if you're an employment lawyer already, feel free to ignore me, because I'm sure you know all this stuff already. But if you don't, then I will give you a crash course on COVID-related employee and employer issues. first, we have this FFCRA, which is the Families First Coronavirus Response Act. That obviously affects a lot of companies. Any company with less than 500 employees is covered under the act, which went into effect April 1st. So the two major provisions under the FFCRA would be the Family Medical Leave Expansion Act and the Emergency Paid Sick Leave Act. So without getting into the specifics of each act, because one can get into the specifics for a very long time with these two, the important thing to know is that under the FFCRA is that in certain situations, employers are required to pay their employees when they cannot come into work for various COVID-19 related reasons. For instance, if they have to care for somebody who has COVID-19, if they have COVID-19, if they are subject to a mandatory quarantine, there's a variety of different reasons that they may have to pay the employee. And it's something that is important for companies to consider when they are balancing their books or trying to decide if they can keep their business up and running during this period of time. There's also the CARES Act, the Coronavirus Aid, Relief, and Economic Security Act, which also applies to businesses with fewer than 500 employees. As Charles just talked about, there's a Paycheck Protection Program wherein loans can be given to small businesses if they qualify. And this is also something for employers to consider as well, because many employers think that they cannot pay their employees, or they think that it would be best if they shut their doors or if they file for bankruptcy or take other measures rather than try and stay into business. But if they explore potentially the CARES Act or a PPP, it may be that any loans that they receive are forgivable depending on their situation, and it may be that they can get some cash in their pocket for the short term in order to make it through and keep their business up and running during this period of time. Another important thing that the CARES Act does is it expands funds for unemployment insurance. So it's giving states more funds to provide people in their states with unemployment insurance. It also expands eligibility for people applying for unemployment insurance. So it's important to encourage anybody that you talk to that mentions that they're unemployed for any COVID-19 related reason or due to COVID-19's impact on the economy or their business or industry, to encourage them to visit the Tennessee Department of Labor and Workforce website, which kind of takes them through the steps for filing for unemployment. And there's a lot wider net now too for people looking to file for unemployment claims, whether partial or complete. So that's something important to know. And if any callers have any questions about the unemployment process, then they can schedule an appointment with one of the employment attorneys to help them walk through the process, whether they're an employee or an employer. So now that we have a little bit of a background on kind of the two major issues that employers are dealing with from an employment law perspective, here's how you can identify any employment law related issues when you're on the phone with a caller or a small business owner, whoever that has a question for you. So let's say the caller is a small business with less than 50 employees, and they're worried, can I pay my people without going out of business? What do I do? So if your caller owns a small business, and I'm talking, I know small is a vague term, but for this purpose, I'm going to say that means less than 50 people. And they're contemplating filing for bankruptcy, or they're contemplating shutting their doors because they cannot afford to pay leave for employees for 10 weeks under the FFCRA. There's alternative economic relief that they can pursue under the CARES Act, assuming that more funds go into the SBA bank. And then also companies with less than 50 employees may be exempt from having to pay their staff in certain instances. There is a way that certain companies can apply to be exempt from having to pay, for instance, the 10 weeks, if paying them under the act would substantially impact the business or put them out of business. The Department of Labor has been issuing guidance on this daily and sometimes multiple times a day. So the process for applying for an exemption is fluid as of right now. They're just asking companies to make a good faith effort to comply with the FFCRA and to keep all records of any leave that they provide people, and to keep records as well showing that you cannot provide leave to your employees. Another reason you may want to refer your call to an employment lawyer is if you're talking to a small business owner and they're talking about mass furlough or mass layoffs. There's a lot of steps and boxes to check with a furlough or a layoff on a major scale, because in certain circumstances, companies are required to provide a particular type of notice depending on how many people they're laying off and for how long of a period of time that they're laying them off. There's a federal WARN Act, and then Tennessee has what's called a mini WARN statute, which applies to companies with, I believe, more than 50, between 50 and 99 employees, because the federal WARN Act is kicked in at 100 employees. So you're going to want to have that person call one of the employment lawyers and speak with them about whether or not they're covered under a WARN Act. Also, a mass layoff could affect the company's loan if they've applied for a PPP loan. So that's another thing that they'll need to consider as well. And then, of course, there's, the implications of layoffs and things like that on FFCRA obligations. And whether a company has to pay one of their people largely depends on when that person was employed and when that person took leave. So that's just always something that's good for an employment lawyer to run through with somebody if they mention anything about furloughs or layoffs. Another buzzword that you may hear is the caller may be self-employed. The CARES Act expands unemployment insurance availability to people who are self-employed. So if somebody calls you and they're self-employed and out of work, it's possible that they could get some sort of economic relief by applying for unemployment compensation. So I would encourage you to either refer them to the Tennessee Department of Labor and Workforce website. They have a big COVID-19 resource page, and from there, there's a box to click on if you're an employer or if you're an employee, and it'll walk you through the process of how to file a claim for unemployment. I hear that it's pretty backlogged right now, but it's important to at least get your stuff filed, whether you're confident that you're covered or not, just in case. And to that note, if the caller mentions unemployment benefits at all, it's important to make sure that they touch base with an employment lawyer. And that's because Tennessee has altered its unemployment compensation process for COVID-19 related layoffs. As I just mentioned, they have this big resource page for people who need more specific information or instructions about how to proceed with their unemployment claims through this time period. So if a caller has mentioned that they've applied or they're looking to apply or they want to check the status, they can consult one of the employment lawyers. Although one caveat is we can't really tell them the status of their unemployment claim, but we can kind of explain the backlog in the process right now and maybe suggest how they can obtain status for their unemployment claims, which is essentially just keep calling and be the squeaky wheel. And then for employers, there's certain things to walk an employer through if they're talking about layoffs and furloughs, because the Tennessee Department of Labor and Workforce has provided employers with certain codes or mechanisms to use if they want to file for unemployment benefits on behalf of their employees. They do ask that the employer and employee don't both file at the same time. It's either one or the other. So it's important to pass that along to employers so they make sure that they can communicate that to their employees if they have to lay them off. If the caller says that they're an independent contractor, they also, under this wider net for unemployment insurance, may be qualified through the CARES Act. So that's another caller that may need to talk to an employment attorney as well. Let's say the caller's a business and they're trying to figure out if they need to pay their employees wages or paid leave. So under the FFCRA, there are certain circumstances where a company has to provide an employee paid leave. And employers can be reimbursed for the cost of that leave through tax refunds or credit process, because I know it can be a big cash flow issue when they're paying out their employees, but no business is coming in through their doors. It's 100% refundable tax credit if the employer is required to offer leave or sick days. So if they fall under that 500 employee benchmark and one of their employees is subject to a mandatory stay-at-home order and they're a non-essential business, so the employee can't work, or if they are considered an essential business, but the employee particularly is unable to work or telework, then they may be required to offer paid leave or sick days. And that is something that they will definitely need to walk through with an employment attorney. Here are some other potential employment issues or buzzwords to keep an ear out for. Again, I don't expect anybody to offer specialized legal direction on any of these issues because employment lawyers are so far in the weeds on all these issues right now. But I would suggest if your caller mentions any of the following topics that you suggest they schedule to call up one of the employment lawyers. So if the caller is an employer who talks about paid time off or employee benefits, or if an employee is saying that they can't go to work because they're quarantined or they don't feel safe or they have to care for a sick child. If any of your callers mention collective bargaining agreements, which is, for those who don't know the employment lingo, that's union agreements or CBAs. So if there's any union involved, that's also a very good time to punt the caller on to one of us, one of the employment lawyers, to talk to them about their issues. If they mention COBRA, and again, if they don't feel safe at work, that may be an OSHA issue or a Tennessee OSHA issue that they need to talk about. Protective equipment in the workplace, the caller may not be sure whether or not they have to require employees to wear them, and employees may not be sure if they have to wear them at their job. So it's always a good thing to run by an employment lawyer to see what the advice is, because again, that changes with CDC recommendations and things like that, which are very fluid during this time. And then, of course, whistleblower protection. If the caller mentions what they believe to be any illegal activity on the part of the company that they're working for or with, that's also a good time for them to be passed on to an employment lawyer that can give them a little bit more specific direction on that as well. So that's all I have for the employment-related issues. Again, these are all very complicated. Employment lawyers are very bogged down with a lot of these issues right now. So I completely understand if this has all been a little bit confusing. But the good news is that you can refer your callers, if they mention any of these issues, to one of the NBA's employment lawyers, and we will be happy to help and provide employment-specific and specialized advice. So with that, I believe I'm passing this on to Tim now. And again, I want to thank all of y'all for volunteering your time and for paying attention to our presentations.
So thank you to Charles, Robert, Mallory, and Justin for that great substantive law training. And once again, thank you to the volunteer attorneys for helping small business owners. Please visit the Nashville Bar Association's website to get registered for the April 29th telephone clinic.